We shall continue the special joint session. Please invite the candidate to the High Court judge position, Troian Tetiana Yevhenivna. Good afternoon. The issue of the candidate, Troian Tetiana Yevhenivna, compliance with the criteria of the competition to fill 23 vacancies of the High Court judges. The PCIe members are present. Names follow. Mary Kay Butler joining by video. The HQCJ members are present. Names follow. Yaroslav Dukh no longer takes part in the session because of his service duties. Roman Sabadash is joining us by video. Tetiana Yevhenivna, is the composition of the Commission clear to you? Yes, it is. Your rights are to make motions and recusals, provide explanations with the consent of the chair, make objections, and appeal the decisions of the Commission. No new materials are being considered in the special joint meeting other than those that the candidate had a possibility to provide in the determined time, in the determined deadline, with the consent of 3 members of the Commission, at least 3, or the motion of the candidate. New materials can be included to consideration in case they significantly affect the candidate's status. Are your rights clear to you? Yes, they are. Do you have any motions or recusals to make? No motions and no recusals. Kedesyuk is the rapporteur in your case. Member Kedesyuk. Good afternoon, Tetiana Yevhenivna. I will now provide a brief report on your dossier, and then we will pass the floor over to the PCIe members. The candidate to the High Court judge position is Troian Tetiana Yevhenivna. She addressed the Commission with her application to be admitted to the competition as an individual having a professional experience of at least 15 years of judicial practice. The candidate was admitted to the participation in the Commission competition and the qualification test. The candidate earned 327.27 score in the test and was admitted to the second stage of the test. In 2004, the candidate graduated from Donetsk National University and earned a degree in law, master's degree in law. She doesn't have academic title or academic degree. She did not teach at the National School of Judges. Her professional experience in law is 20 years. She worked as legal counselor, the head of legal department of legal support in private sector and banking sector. By the presidential decree of October 2013, the candidate was appointed at the position of the judge at Kirovsky District Court in Makiivka, Donetsk Oblast for 5 years. She took the oath in March 2015. By the presidential decree as of February 2015, the candidate was transferred for 5 years at the judge position at Sosnivsky District Court in Cherkasy. And by the presidential decree as of December 2019, the candidate was appointed to the aforementioned position permanently. The candidate has a judicial experience more than 5 years and is fluent in Ukrainian. She has a clear criminal and disciplinary record. And that is it. Thank you. Over to Robert Brookhuizen, the chair of PCIe.
Thank you, Mr. Chair. Please pass the floor to Norman Haas, who is the rapporteur.
Yes, thank you. Good afternoon, Ms. Troian. Yeah, I'm from Estonia. I'm a lawyer and foreign prosecutor, and I'm your rapporteur. And thank you for your participating this important competition. And also thank you all the answers are already provided during this written and answer rounds for today's interviews. And but this is the public interview, and I will cover once again some of the topics, and of course you can remain answers already provided to us before, but if you have anything to add, you are free to do that. I see from your biography that you have served as a judge for almost 10 years, and my question is, in your work as a judge, have you specialized in a particular type of the cases, such as criminal or civil matters? Because you are judged in the general courts, and I know that the general courts are dealing with different types of cases, both civil cases and criminal cases. Do you have any specializations in your court?
Yes, I work at a district court, and I was given civil specialization. I'm also an investigating judge that ensures the human rights of the parties at the early stages of case administration. I also have administrative cases, and as per criminal cases, I'm a member of a panel of judges. I'm not a rapporteur, but just a member of the panel when it comes to criminal cases. And I have functioned in such roles for 10 years.
Can you describe or outline most of the complex or severe criminal cases where you have acted as a judge, as a member of the panel?
So currently we have 3 criminal cases related under Article 191. Their consideration is ongoing, and as I was an investigating judge, I have dealt with motions and cases that were complex and time-consuming. Also means to ensure criminal proceedings, selection of a preventive measure, issuing court orders for searches. All such motions require complex analysis within a certain time limit. I couldn't call them the most complex, but I think that they are they require much attention and focus.
Thank you. I'm not so familiar with Ukrainian criminal code, so I don't know what this Article 191 is about. So maybe I clarify just, do you have educated corruption or corruption-related cases as well as a judge in the panel, in the trial phase, not as an investigative judge?
As an investigating judge, I consider motions and means to enforce criminal proceedings in corruption-related cases. Article 368, abuse of power, proposal of unlawful benefit. I select the preventive measure in such cases and consider other motions within the framework of those criminal proceedings. And with regards to Article 191, embezzlement, those cases are ongoing. They are being considered by the panel of judges.
In your view, what is the difference, or what do you think? What is the difference between administrative justice in the general local court and in a specialized anti-corruption court, where you are applying? Have you idea? Can be there any difference with your present work as a judge?
I believe that the cases at the Hague Court are more complex and broad. They require comprehensive knowledge. But I have also dealt with cases involving property, and Hague Court cases usually have an element property. So property is a part of the case, and of course the Hague Court cases are more complex and they require a very rigorous approach in terms of procedure. Moreover, the cases under the jurisdiction of the general jurisdiction of general courts, they also deal with cases similar to ones considered at the Hague Court regarding penalties, sanctions, and I think my experience could strengthen the Hague Court in this regard.
I know that you are also participating in a competition for the position of judge in a specialized administrative court of appeal. Is that correct?
Yes, I'm running for judge's position with other courts, but I believe that this competition is a priority for me because the Hague Court specialty is the closest to the specialty I have at the moment. Criminal, civil, it will enable me to consider cases with elements that involve property and administrative cases. So for me, this competition is a priority, and I hope to pass this competition.
And considering the fact that at the moment you are running for several higher judicial positions comparing with your present one, so what is your main motivations to go further from your present position?
I believe that after a certain period of time, evolution, growth should happen. I would like to go from broader specialty to a narrower specialty, and the Hague Court has a narrower specialty compared to the specialty I had in the past.
Thank you. I'd like to cover a couple of things also related to your declarations. according to the file, 2011, your husband purchased a Nissan Qashqai car, built the same year, 2011, for 216,000 hryvnias. And you indicated your answers that the funds for this purchase came in particular from the sale of a former car, Volkswagen Golf, that belonged to your husband's father, and as well as partly from your own saving and from credit from the bank. And as it happened already 2011, you stated also that the documents relating to those transactions are not reserved because also of your relocations because of the war. But now the question, can you recall approximately what was the amount receiving from the sale of the previous car, Volkswagen Golf?
Так, приблизно ми пригадали, що це
Yes.
було орієнтовно 12-13 тисяч
about
доларів.
12 to 13,000 US dollars. And that was not enough to buy a new car, Nissan. That is why we asked for loan and also we also used our savings. In my dossier, I indicated information that the car Volkswagen was registered in my father-in-law's name. And in November, Nissan was bought. And you can also see 64,000 hryvnia. We took it as a loan and we paid it early. As of December 25, 2025, the vehicle is on the state property register. So around 12,000 US dollars.
Can you also recall that was this payment when you sold Volkswagen Golf made in cash or via bank transfer?
Так, це було готівкова форма.
Yes, the transaction was done in cash through an agreement between the parties in cash.
Was this in hryvnias or in US dollars or any foreign currencies?
І я думаю,
I
можливо,
think
частково було в
maybe in part it was in hryvnia and in part it was in US dollars in foreign currency because our savings were in hryvnia, if I remember correctly. So in part it was in hryvnia.
Can you remember?
Чи пригадуєте ви,
According to your biography, you became a judge 2013, if I'm not mistaken. So you wasn't judge at that time. Where you was working at that time? Can you remember?
Я працювала у фінансовій установі керівником
I was working at the financial institution as the head of legal department, deputy head of legal department. And before I was appointed judge, I was the main specialist of the legal department of the bank unit. Basically, another person was appointed instead of me, and I was transferred to the position of the main specialist so that the department could keep functioning without any pauses.
Let's go further with this Nissan Qashqai car. We know, according to the file 2024, your husband sold this car, your mother. in the with the price 276,000 hryvnias roundly. Can you explain the meaning of these transactions? Why the car was sold inside the family to your mother?
Оскільки автомобіль вже на той момент було
13, the car was used for 13, 14 years. We decided to sell it, and we decided that the vehicle was in normal technical condition, and we decided to offer it to the parents, and the cost was established by the technical service center, and the parents bought this vehicle, but they didn't use it for a long time because the health condition of my father deteriorated and he started avoiding driving a vehicle. So in 1 year approximately, they sold this vehicle to a third party. So it was an attempt of my parents to use the car.
Thank you. But how was the sale price of the car decided when it was sold to your mother?
Оцінку автомобіля здійснює сервісний центр.
Such an evaluation is being done by a service center of the traffic service. They assess the year of manufacturing, and this cost was corresponding to a market price. It's from 7 to 11,000 at that point. The exact cost would vary on technical condition, whether there were traffic accidents in which the vehicle would be involved or some visible damages. And the assessment was made by the service center of the administration, and it actually suited my parents, and they decided to sign the contract so that the ownership was transferred. And in 2024, I used the vehicle for some time, and after my parents purchased the vehicle, I also kept using this vehicle to help my parents in the interest of my parents. So the assessment was made based on the service center of the Ministry of Interior.
Thank you. About this assessment made by the service center, was this assessment related only to the technical conditions of the car, or indicated that assessment also the possible price of the car? Was this possible price of this kind of car written down in this assessment? Or?
Окремої оцінки не було, вона, можливо, залишилася в базі цієї державної установи, нам не роздруковували.
Probably an assessment kept in the database of that institution. It was not printed out for us. As far as I know, they have certain formulas that they apply based on the year when the vehicle was manufactured and some other criteria like the model. As far as I remember, the specialist looked at the car, but we were not provided a separate printed assessment. The price was indicated in the contract, sales and purchase agreement when it was drafted by the service center, and the specialist was the same, the one who assessed and the one who registered the ownership.
Thank you. Was this transactions between your family or your husband and your mother in cash, or was the price paid via bank transfer?
As far as I know, the payment was done in cash over several days, maybe in parts, as far as I know. But it was a transfer in cash.
And we know that your mother income 2021 to 2024 was not so high than the price of the car. Can you indicate what sources of income allowed your mother to buy this car?
Yes, it's true. I provided the documents confirming the income of my parents. They got pensions. In particular, my father has professional diseases, and his income is approximately 25,000 hryvnias as of 2024-25, and my mother's pension is approximately 5,000 hryvnias. So they have some savings. They can save certain sums. Unfortunately, I didn't have time to get the certificate of social payments for my father, but I ordered the certificate about the professional disease, but I didn't have enough time to get it because it takes up to 10 days so that it's issued.
Thank you. And we know that in July last year, your mother sold the same car, and then the price was almost 500,000 hryvnias, exactly 487,000 hryvnias. Of course, the rates changed, I think, during that year also, but anyhow, the new price is significantly higher. So how you can explain that during 1 year the price of the car rose so much?
Well, when my husband sold the vehicle to my parents, they went to the service center, and there was a market assessment, and my mother was fine with it. But when my mother was selling the vehicle, we posted an announcement on the internet, and it took some time for it to stay there. We improved a little bit the technical condition of the vehicle, but not much, as far as I remember. We improved the automatic gearbox. Maybe we painted some elements, and there was an arrangement with the buyer.
Вони домовились за таку ціну.
So the buyer and my mother came to an arrangement, and it suited everybody. And yes, the price was higher.
Was these transactions made in cash or via bank transfer? You know that?
Ну, наскільки мені відомо, готівкою,
As far as I know, in cash, maybe partially in hryvnia and partially in foreign currency, as far as I remember from my mother.
Thank you. Let's move on. The next topic what I'd like to ask about is one bank loan, and according to the file, in July 2005, you entered into the loan agreement with the bank Ukrsibbank, and the amount was $26. And the aim of this loan was buying an apartment in the city of Donetsk. And according to the terms of the agreement, the end date of the loan agreement was 2026 July, and the interest rate was 10%, later increased to 15%. But after 2014, for beginning of the war, I think was the reason you stopped making regular loan payments to relocations from the temporary occupied territory and losing your source of income. And is that correct that after 2014 you didn't pay any more this loan until 2024? It was settled finally.
Так, дякую. Дійсно, був оформлений кредитний договір
Yes,
14
there was a loan of 14th of July 2005 for a period up to 2026. It was a loan to purchase an apartment where we later lived, starting from 2006. And so we were making payments according to the schedule of the loan agreement till approximately the end of 2024, when partial occupation started of Luhansk and Donetsk regions started, and we left, and we realized that unfortunately we had to start our life in a different place, and I decided to temporarily stop the payments. At the same time, I contacted the bank in different cities. We traveled around different cities because we couldn't understand where we would be employed and where we would reside. And I was explained in the bank that such situations were frequent. At the same time, they were not offering any payment holidays, or they didn't offer to restructure the loan. And but I was respecting the schedule of repayments. To the contrary, I paid the principal amount, and since the end of 2014, I stopped repaying the interests, and they started accumulating. And so we can see that from the certificates I provided. At the same time, I communicated constantly with the bank to sign a document to restructure the loan, to get it delayed, but the priority was were those whose housing was damaged or destroyed. And but I provided my contact details, how to reach out to me, and where to find me. And later, a program was offered to me, so the interests were accrued, and the principal amount remained the same, but I don't have access to this apartment. It's basically lost for me. And the bank made a decision that if I make a certain payment, all the other interests and partially the principal sum would be annulled, cancelled, and there are documents confirming that, but we didn't sign any additional agreements. It was the decision made by the credit committee of loan committee of the financial institution.
Is that correct that in 2024 you paid $10,000 to the bank, and that this was the final amount, and it covered the principal amount and possibly interest, and that was after that the loan was settled?
Yes, in 2024, the bank considered my package of documents and made the decision with a limited period, with a limited time frame. And if I managed to pay this amount within that established period, the loan had to be cancelled, as well as the interest. So I paid these funds till December 2024, and there is a certificate confirming that I have no outstanding liabilities, and I repaid the loan.
Can you clarify what proposed expenses the payment was made, this $10,000 in 2024? I understood that this amount was paid not in once, but during this year. Or was paid as of one transfer?
According to the schedule that I was provided, the first installment in September 2024 was in the amount of $7,000. It came from my savings, and over the next month, October, November, and December, I paid $1,000 a month, and it was from the remuneration I was receiving as a judge. Some of a part of it was used to repay the loan.
Do you know, was a similar loan write-off programs applied also other borrowers in a similar situations? Your family?
У нас в родині інших таких кредитів немає, але
in our family there were no cases like that, but I know that this program corresponds to the requirements of the law on protection of rights and freedoms of internally displaced people. There are certain benefits for the displaced people who have these outstanding loans, and the financial institution explained to me that they were considering many cases like that, and they were considering them one by one, and it takes a lot of time to analyze these packages of documents and all the circumstances of every candidate. And of course, they were considering the mortgage items as well. As far as I know, the apartment in my case is not damaged, but again, I cannot use it. So it was not an individual program. That's something widespread for displaced people.
Thank you. And my last question is about some of your churches in the court information systems, and we know that you have searched for yourself. For example, in 2023, you looked for your own name in the decisions of the High Anti-Corruption Court. Can you explain or recall why you made those searches? What was the reason or necessity to inquire your name related to
Я здійснюючи пошук своїм прізвищем,
As I was searching by my name, I actually can explain it by the claims against judges of Sosnivsky court, maybe in that context.
виявилися. Ну, взагалі-то я шукала в адміністративному суді.
Actually, I looked by my name within administrative jurisdiction, courts of administrative jurisdiction, and civil jurisdiction, whether the bank didn't initiate the proceedings due to the loan. That's all I can remember.
Інших пошуків я не пригадую.
I don't recall other searches.
Okay, but you just confirmed that one aim to make those search was to figure out that if the bank has initiated some sort of claim against you as a private person, or how it was related to your job as a judge.
Так, я могла передивлятися.
Yes, I could, looking by my name, or to clarify that issue with the bank, or to, in the context of other claims submitted against other judges of my court.
Okay, thank you. No further questions. You, Mr. Chair.
Thank you, Norman. Just looking around me. No? Mary? No? Please, back to you, Mr. Chair.
Дякую, Роман Анатолійович.
Thank you, Роман Анатолійович.
Дякую.
Thank you.
Так, буде теж кілька запитань.
I will also have a few questions.
Рухатися з блоку мотивація.
Let's start with the motivation part.
От, будучи суддею, ви казали, що
Being a judge, you mentioned that you had criminal proceedings with the status of investigative judge. Tell us, please, what gives you a competitive advantage among other candidates to become a HEC judge? Well, I don't think I have a special competitive advantage. I think all the candidates have their own professional path and deserve what they have, but I have an experience that could strengthen the Hague, and I could get additional skills from myself. So, as I said, I would improve in my professional capacity as more complex reasoning and more strict procedural discipline are required in HEC. Thank you. Then I will refer to your motivation letter. you indicate that you would like to have an opportunity to make a real contribution in ensuring justice in anti-corruption area. And you state that it's in the hack that judges have all the necessary means to ensure efficient and unbiased administration of justice up till material means. Tell us, please, what does a local court lack? You underlined that the hack has higher procedural guarantees. What about the local court? Have you faced any circumstances that didn't provide full guarantees to you? No, there were no particular circumstances, but there are things that could be improved. I would like to strengthen the High Anti-Corruption Court, also in view of the material means of this court, the means it can provide to the judges. Our local court has all the necessary things. I cannot say that something is lacking there. All right, thank you. Would you like to add something else? Good. The recommendations that candidates provide are optional, but you added a recommendation from the judge of Yahotinsky District Court. We welcome that, of course, but why is this judge from a different court, Yahotin court? Actually, in the past, we worked together and we continued communicating. We worked together at the financial institution for 15 years, even more. So I contacted him and he provided such a recommendation. So it was your professional activity before the position of a judge? Yes, we keep communicating. Thank you. And according to the President's Act, you were appointed in 2013, but you administered justice in 2015. What was the reason for that? It was the reason that I couldn't influence because the newly elected President Poroshenko made an oath, and so I couldn't start earlier. Okay, let's move further about the disciplinary complaints in your file. There are over 20 complaints for the last 10 years. They concern your professional activity. And I can see that most of them were rejected. And the Commission doesn't have the latest information because the last claims came in November and December 2025. So were there any proceedings initiated with regards to these last 3 complaints? No, no one called me about that. The latest explanations that I provided with regard to the claim from November, so that was a written explanation, but I have no information about other complaints. Thank you. In this case, I will ask another question about the declaration you filled in, and actually, in particular, about the residence, the place of residence of the child. You don't indicate that because the child no longer lives with you. No, the child lives with us. Considering that she was a minor, and the place of residence of the child is the place of residence of the parents, I will indicate it in future that the child resides with us at the same address. So the child remains with us.
Right, so it's a mistake. Yeah. Okay, then regarding financial issues, and that will echo the questions asked by Norman regarding your debt restructuring. In the percentage, which amount of debt were you relieved from? So the main debt was written off more than 577,000 hryvnia, about $14,000. This is the main debt, and that is stated in my declaration as a written off debt. Then 581,000 100,000 hryvnias as interest was also written off, and I didn't indicate this sum because the interest is not an asset because I didn't acquire anything. And when the body of the debt, body of the loan is written off, then so interest is not an asset, and to my knowledge, they're not reflected. They should not be reflected in the declaration. 577,000 hryvnia is the main debt, the body of the debt that was written off. Is my understanding correct that from the financial obligations that you had before the bank wrote off 65% of the debt, and $10,000 was paid by you. So let's operate with approximate numbers. So if you take the certificates, the 3 certificates from the bank that I submitted, they reflect the movement of funds from 2005 to 2014, and $24,000 was paid as interest, and the body was paid as about $12,000 to $13,000. It means that half of the body was written off by the bank, and the interest, 13,000 of interest, and $10,000 covered
Після технічної перерви продовжується засідання.
We can continue the session after the technical break.
Ви надали пояснення в
So you submitted your explanations about the amount the bank wrote off from your debt. Are you adding to this information anything else? Yes. So the sums that the bank wrote off need to be considered with respect to all the sums that I had paid before. If the general amount was 26,000 US dollars, I paid until the debt, until I asked for debt restructuring, I paid 24,000 US dollars of interest and 12,000 of the body. Later on, the interest increased, and there was still a half of the main debt remaining as a remaining sum. So I paid 46,000 US dollars before the debt was restructured. And what was written off? It was the amount of $26,000. The amount written off is almost twice as little as the initial amount. Okay, so it means that you borrowed one sum and you returned much bigger sum. You're declaring savings in cash. In 2018, it was 10,000 US dollars, then 13,000 US dollars. And in last year, 23,000 US dollars. So the assets that you own, could you use them to pay the debt in order to not have that much of interest? Do you think it is viable, economically speaking? I lost the access to that property because I had, so to say, feeling of social justice, a social injustice. It didn't feel right to me to use all of my assets to pay for the apartment to which I haven't had access for 12 years. And there was programs for those whose accommodation was damaged. So I decided to turn to some benefit program in order not to refuse in order to respect my obligations. Okay, it is clear. Thank you. And when did you submit your application for debt relief? I would write to the bank constantly from 2014. And then the last program, the bank accepted my application and considered it. So I've got our exchange of emails as a proof from 2014. Okay, thank you. Then is it the bank where you worked at some point? Yes, I worked there from 2003 to 2007. So it was quite a long time ago. Yeah, none of those colleagues who I knew still work there. Thank you, Tetiana. I've got no other questions. Maybe colleagues do. Any other questions? Ruslan, go ahead. Thank you.
У мене просто питання, ну це ми навколо цього кредиту
We actually
почав дослідження декларацій.
are talking about this loan, and I also had a question about this. So you got a loan in 2005 to buy real estate objects, then you paid the loan, then some conditions occurred, circumstances beyond your control occurred. When was it? Summer 2014. So summer 2014. And in fact, the debt relief happened 10 years later in 2024. Look, as of 2015, what was your debt? Like, how much was your debt? I think it is important to state it because my next question builds on that. In 2015, if we take the body, it's 13,000 US dollars. So according to your declaration, it's more than 20,000 US dollars. Yeah, first I declared the whole amount of the loan. And at first stages of declaring that, I stated just the whole amount of loan, and in 2018 I started stating the more detailed sums. So first it was 13,000, then interest was 1,000 US dollars. 14,000 US dollars is your debt in 2015. In your declaration for 2015, 45,000 US dollars is declared as your asset. You have a debt 14,000 US dollars. You have an asset of 45,000 US dollars. It's 3 times as big as your debt. What kept you from paying your loan in 2015 in order to just forget about this issue and close it? So the savings, indeed, I wanted to use them to pay the debt, but we needed to leave the territory, the temporarily occupied territory. And my parents too, and thanks to those assets, we managed to return to normal life. We bought a property in 2016, accommodation. So we didn't use these assets to pay your debt, but you used it to buy an accommodation, housing. Yeah, I talked to the bank about that, and we were deciding whether we needed to move to a different city and get employed. But we also needed to buy accommodation, having a small child. And there was also a bias towards IDPs. It wasn't easy. So after purchasing that accommodation, you still had something, $15,000. So you've got 15,000 US dollars that would be enough to pay your debt. So you would have
Але і тут ви вважаєте, що цього не потрібно робити. Чому? Тобто міркування ті самі, да, що треба влаштувати життя.
You would have both the accommodation and you would pay your debt. Yeah, but I was waiting for debt relief, and I hope that the temporarily occupied territories will return under the governmental control, and that issue could have been settled in the regular manner. There was no certainty back then. So regarding your skills to work as a high court judge, what is the difference between a proposal of unlawful benefit and demand. A demand means a threat and negative consequences that will happen unless the individual refuses to give unlawful benefit. And in which case, the situation cannot be qualified as a demand. Then there is no threat, and that's it. And regarding the one who is giving the bribe, the consequences. And if the individual tries to evade the law, how about the one who demands the unlawful benefit? Let's say individual is trying to settle some issues around motion to select a preventive measure and proposes an unlawful benefit to the prosecutor or the judge, and then says that it was a demand on their part. Will it be a demand in this case? No, it won't, because a demand did not take place. And if we establish that threats were made, so according to the materials say that the person demanded an unlawful benefit in order to have the issue settled. Will it be qualified as demand? If there is videotape, yes, but the person was pursuing unlawful interests. Okay, thank you, Ruslan. We've got 2 minutes. I'll be brief. A question regarding motivation. If I'm not mistaken, Tetiana, you also run for the judge position at the Specialized Administrative Court, and you await the qualification test. Could you tell me, please, which of these competitions is a priority to you and why? As I said before, this competition is a priority because this Hague Court specialty is the closest to my current specialty. This is criminal cases, administrative law, and in case I win this competition, I will be happy to choose the Hague Court as my future job. Okay, thank you. If there are no more questions, Tetiana Yevhenivna, you've got one. Could I also ask one more question still? Yeah, okay, Roman, go ahead. We didn't hear you. So my question is, in the court register, you look for a surname with the prefix attorney. Why would you do that? So it may be justified when you have a certain party. Why are you searching for an attorney's surname? Because if it's about an application to be absent from a different hearing, regarding the decisions of the Hague Court, regarding some searches, in some searches we can see surnames. At some times it was a random surname, but mostly, what was it related to? It was just 3 times. It may have been a party of a very highly resonant case. So if I call you the surname, then you would see that it is not a party of a high resonance case, Riesnik, a woman. So it's not really a public figure or a resonance case. I think it may be related to the fact that I was getting ready for the competition.
Добре, да. І це не системно, воно просто виділяється.
It's not systematic, but some reason it drew my attention. Is it it? Then Tatiana, if you would like to share anything, you're welcome. Thank you for this constructive conversation. I would like to thank HQCJ and PCIe members. And I hope you will fill the vacancies with trustworthy candidates. And I wish you inspiration and constructive cooperation. Thank you. Thank you for your participation in the interview. We have reached the end of our agenda, and we